Welcome to What's New in Municipal Law Part 2, Recent Court and Appellate Tax Board Decisions. Now we are going to talk about some recent decisions regarding tax collection issues and public employment. The first set of cases will be on tax collection issues. The first case is Tallage Lincoln v. Williams, a Supreme Judicial Court case decided on August 19, 2020. This case deals with tax title assignments. It is an appeal from a land court decision. In this case, the property owner Williams didn't pay his 2011 real estate taxes, so the New Bedford tax collector performed a tax taking and a tax title account was established in the amount of the unpaid tax, 14% interest and costs to date. Once the tax title account was established, 16% interest began to accrue on the balance. The taxpayer subsequently failed to pay the next 4 years of taxes, and those unpaid taxes were certified to the tax title account. Instead of moving forward with the tax title foreclosure itself, the city sold the tax title account to Tallage under Section 52 of Chapter 60 for $22,901.97. This was the minimum price required by law, and it represented the taxes owed, accrued interests, and costs. Tallage then filed a foreclosure action in the land court. The taxpayer filed an answer but continued to not pay taxes. Tallage paid the taxes for these intervening years, 2016 through 2018, to protect its investment. Tallage moved in the land court foreclosure action for the redemption amount to include 1. The unpaid taxes for fiscal year 11 through 15, plus interest and costs at time of Tallage's purchase, and 2. The subsequent delinquent taxes paid by Tallage for fiscal year 16 through 18, plus 16% annual interest. The land court agreed with Tallage regarding amounts within number 1, but not the amounts within number 2, which were the taxes Tallage paid after it bought the tax title account from the city. So Tallage appealed, and the Supreme Judicial Court, on its own initiative, transferred the case from the appeals court. Tallage argued that Section 52 of Chapter 60 puts an assignee of a tax title on same footing as a purchaser under Section 45 at a tax sale. The court disagreed. It said Section 62 distinguishes between assignees and purchasers, allowing purchasers of collectors' deeds, but not Section 52 assignees, like Tallage, to add subsequent tax payments to a redemption demand. The court said that the only rights of an assignee are those explicitly defined in Chapter 60 of the general laws. And Chapter 60 doesn't state that an assignee has a right to recover subsequently paid taxes, with interest, by adding them to the redemption amount in a tax title foreclosure proceeding. The court also said that case law instructs it against declaring rights for assignees that are not explicitly mentioned in Chapter 60, and that Tallage will have to address the taxes it subsequently paid through a separate lien under Section 60. The land court decision for taxpayer was upheld by the SJC. The next case is the Town of Ware v. Owners Unknown. This was a land court case decided on January 31, 2020. This case involves an attempt by a property claimant to vacate a land court decree of foreclosure entered 10 years earlier in favor of the Town of Ware. The subject property was a 34-acre undeveloped landlocked parcel in the Town of Ware. The assessors could not identify the owner of the land, and after they conducted a diligent search of records at the Registry of Deeds and Registry of Probate, they requested authorization from the Commissioner of Revenue to assess the parcel to owners unknown for fiscal year 1998. Under Chapter 59, Section 11 of the General Laws, the Commissioner granted such authorization. The fiscal year 98 taxes were never paid, so the collector made a tax taking on October 17, 2003, and the instrument of taking was duly recorded at the Registry of Deeds. The town treasurer, on July 28, 2004, filed a petition in land court to foreclose the right of redemption. A diligent search was conducted by the land court examiner to determine actual ownership of the parcel, but to no avail. As a result, the land court ordered a service by publication, which appeared in the December 1, 2005 edition of the Ware River News, a newspaper of general circulation in the town. Since there was no response to the notice, the land court on March 7, 2006, issued a judgment forever foreclosing all rights of redemption, which was recorded in the Registry of Deeds. The parcel became a tax possession on the books and records of the town. To raise revenue, the town in October 2008 gave notice of a public auction of this parcel to take place in December 2008. The auction did not take place, however, because the new owner of an adjacent parcel by virtue of his May 2008 deed claimed ownership of the subject 34-acre parcel. The claimant was Whole Forest Lands LP. The town, in response, withdrew the parcel from the auction. No attempt was made by Hull to prove its ownership of the 34-acre parcel in the next 5 years. The town decided to again schedule an auction of the 34 acres and publish notice in the newspaper of a February 28, 2013 auction. Hull again wrote to the town protesting the sale, but this time the town proceeded with the auction. Hull appeared at the auction, submitted another protest letter and a bid, but it was not the high bidder. A treasurer's deed in the name of the successful bidder was recorded at the Registry of Deeds on March 25, 2013. Hull then hired a surveyor and a conveyancing attorney who filed a motion in land court to vacate the judgment that was entered more than 10 years before. Under the provisions of Chapter 60, Section 69A of the General Laws, a petition to vacate a judgment in a tax foreclosure case must be filed within 1 year of entry or be forever barred. There is an exception, however, where there has been a denial of due process. In the case at hand, the town's due process obligation was to conduct a reasonably diligent search to find the owner and serve notice. Title searches were conducted by the town and the land court examiner, which led to service by publication. In reviewing the events, the land court did not find any evidence of a rush judgment. In the court's view, there was no denial of due process. Even though it had actual knowledge of events in 2008, Hull did not establish ownership of the 34-acre parcel and never offered to pay the back taxes. Years passed before Hull had its own property surveyed and hired an attorney. In the court's view, even if there had been a due process violation, the time to assert that claim had passed. Consequently, the land court found Hull to have acted unreasonably and denied Hull's motion to vacate the judgment issued in 2006. Today, because of amendments under the 2016 Municipal Modernization Act, assessors can make an owner-unknown assessment without the Commissioner of the Department of Revenue's approval. The next 4 cases deal with municipal employment issues. The first case is Plymouth Retirement Board versus Contributory Retirement Appeal Board, decided by the Supreme Judicial Court in December 2019. This case involves creditable service in the public employee pension system. It involved police officer Antonio Gomes, who served as a permanent intermittent police officer before he became a member of the Plymouth Contributory Retirement System. Permanent intermittent police work is sporadic. One works when called upon. In 1998, Gomes purchased retirement credit for his prior intermittent work. However, in 2003, the Public Employee Retirement Administration Commission, PERAC, informed the Plymouth Retirement Board that Gomes should not have been charged. So, Gomes was refunded. 10 years later, the Contributory Retirement Appeals Board, CRAB, decided the case of McAloney v. Worcester, which said that firefighters must remit payment to purchase retirement credit for intermittent work. So, the Plymouth Board then advised Gomes he must again remit the funds that were previously refunded to receive retirement credit. Gomes appealed to the Division of Administrative Law Appeals, DALA. The issue is whether Section 42B of Chapter 32B of the General Laws relieves police officers from paying to obtain creditable service for prior work as a permanent intermittent police officer. The appeal wound its way through the system as follows. First, DALA said, Gomes must pay, and CRAB said, Gomes must pay. Then, the Superior Court said, Gomes does not have to pay. And when CRAB appealed the Superior Court decision to the Appeals Court, the SJC transferred the case to itself. On appeal, the SJC noted that retirement benefits are based upon creditable service and other factors. Some intermittent service rendered before becoming a member of the retirement system is creditable upon petition to the local retirement board, and that board determines how much creditable service is available for previous intermittent work. The SJC also noted that Chapter 32, Section 42B, applies specifically to creditable service for police permanent intermittent time and requires 1 year of service credit for any time spent during a calendar year as permanent intermittent officer, but Section 42B is silent whether payment for service is required. However, under Section 42C, to acquire creditable service for previous intermittent work, members must remit payments with buyback interest, and there are no express exemptions from this purchase formula. To determine legislative intent, the court said it must consider Chapter 32 as a whole. The court concluded that Section 42B is silent on payment for police intermittent service, not because the legislator intended credit for past service without payment, but to establish how much service is credited instead of leaving it to retirement boards. The court decided that the officer must remit payment to receive credit for service. The next 3 cases involve appeals of decisions of arbitrators in public sector labor management disputes. The first case is City of New Bedford versus the New Bedford Police Union. In this case, the police union filed grievance against the police chief, alleging the chief's actions in assigning officers to conduct background checks as part of their regular duties violated the collective bargaining agreement, CBA. It required the chief to assign officers to perform background checks outside of their regular work. The city countered that the CBA did not preclude the chief from taking such action, as it enhanced public safety and was within the chief's managerial rights. The arbitrator ruled in favor of union, holding that the chief's actions violated the CBA. The chief's actions did not enhance public safety. It was really a ruse for the chief to avoid paying overtime to officers performing background checks. The arbitrator held that the chief was required to make assignments per the CBA. The city appealed the arbitrator's decision to the Superior Court to vacate the award. On appeal, the Superior Court found for the city, stating the arbitrator exceeded his authority by substituting his judgment and decision-making for the chief's. On further appeal, the appeals court also ruled for the city, holding that the CBA provision infringed on chief's non-delegable exclusive assignment authority and city cannot be required to surrender it, even voluntarily through a CBA. We note that this case is unusual, as it is rare for a court to overturn an arbitrator's decision. City of Newton v. Newton Police Association. This case involves another labor dispute between a police department and its union. Here, the Newton Police Association filed for arbitration when city denied payment of 2 simultaneous police detail fees to 3 officers who had only worked 1 detail. The first payment was in relation to a canceled detail which they did not work. The officers also performed regular detail work during the same time slot. The collective bargaining agreement required officers to be paid 4 hours detail pay for every detail lasting less than 4 hours. The city's agreement with parties hiring the details provided for a late cancellation fee equal to 4 hours of detail pay for the reserve detail officers if the detail was canceled within 2 hours of its start. The arbitrator ruled in favor of the union after determining that a canceled detail is nonetheless a detail under the CBA. He decided that the officers are entitled to the required 4-hour minimum detail pay for the canceled detail. On appeal, a Superior Court judge ruled in favor of the city, vacating the arbitration award, and the police appealed to the appeals court. On appeal, the city claimed that the arbitrator's award violated General Law, Chapter 40, Section 22F, which provides that the city may fix reasonable charges for city services. The city also claimed that the arbitration award compensating the officers for 2 details, when they only performed work on 1, was a windfall. The appeals court said it could not say that the late cancellation fee is in direct conflict with General Law, Chapter 40, Section 22F. The court also said that the arbitrator's determination that a canceled detail is a detail under the CBA is beyond scope of court to question absent fraud, and the court upheld the award of detail fees to the officers for the canceled detail. Further appellate review, FAR, has been requested by city. The third and final case involving labor disputes involved the Dracut Firefighters Association. This dispute arose from a new policy preventing on-duty firefighters assigned to the east and west fire stations from attending union meetings at the larger central fire station. The arbitrator found that the chief's implementation of the policy without bargaining was a clear violation of a provision of the collective bargaining agreement that allowed union meetings for all firefighters at the central fire station. The town argued that the town's public safety needs, including decreasing the fire department's response time, required the chief's new policy. The chief promised to provide the firefighters in the district station with remote technology, such as Zoom, that would allow union members to participate remotely. In deciding the union's favor, the arbitrator noted that the chief did not apply this new rule to inspections, memorial services, public relations activities, training, drills, refueling, or similar activities at the central fire station. The arbitrator found that the chief's public safety rationale for his new policy was undermined by his inconsistency in allowing travel for other activities. The city appealed the arbitration award to the Superior Court. The Superior Court vacated the arbitration award on the ground that the arbitrator exceeded his authority by infringing on the non-delegability of the chief's authority regarding the deployment of his fire department personnel. The union appealed to the appeals court. The appeals court balanced the principle of non-delegability, which extends only as necessary to preserve the public employer's discretion to carry out its statutory mandates, with the public policy that favors collective bargaining. The appeals court found for the union, after concluding that, due to the numerous exceptions to the chief's policy, the city did not make a clear showing that public safety considerations were paramount. And that concludes Part 2B of What's New in Municipal Law. Please join us for the next segment, Part 2C, regarding finance and land use law.